Welcome back. This is Roger Royce with the 10,000 Startups podcast. And this week, I want to talk about artificial intelligence developments in California, in particular and federally. As you know, I am the host of the 10,000 Startups podcast, where each week we bring you original legal content of interest to startups. I'm a partner with Haynes Boone in Palo Alto, California. I work with emerging growth and venture capital. And because I'm in California, I'm going to focus on the California rules. So, first of all, let's talk about the California AI update. What is now law and what to do about it? Now, you remember a year ago or so when we did this presentation or this podcast, we talked about what was speculative reports, draft bills, a lot of watch this space. Well, that's no longer true because as of now, some of the most consequential AI rules in the country are now in effect in California. One aimed at employers, another aimed at the companies building the most powerful AI models. So the era of wait and see is over and the era of compliance has started. So what I'm going to cover is four things. First of all, the Frontier AI Policy Report. Secondly, what's going on federally. Thirdly, AI and employment, which is a big deal in California. And then fourthly, the Frontier AI Safety Law, which is now in force. So that's my roadmap. These are kind of the things to watch. And let's dive in. So first of all, the California Report on Frontier AI Policy. That's the document that really frames everything. And to give you some backstory, you might recall that in 2024, the legislature passed a bill, very ambitious AI safety bill. Our governor vetoed it because it was too blunt an instrument. And then he convened a working group of leading academics, researchers, and asked them to come back with a framework. Well, we have that framework. We have that report. That's the result. And the organizing philosophy of that framework, I would say, is trust but verify. And the idea is that you don't want to strangle innovation, especially in California, but you also simply cannot just take the developer's word for it that their systems are safe. So the recommendations cluster around a few principles: evidence-based policymaking, public-facing transparency, adverse event reporting, essentially a duty report when something goes wrong, and what they call adaptive regulatory thresholds, meaning that the rules should adjust as the technology advances, because this technology is advancing super quickly. So you might be wondering, why regulate this at all? And the report basically identifies the specific harms that it's worried about. And this is a list that's worth remembering because it's going to show up everywhere now. Biological misuse, for example. Think about AI lowering the barrier to bioweapons. Cyber attacks, that's pretty obvious. We've just seen a big example of that recently. Disinformation and misinformation, systemic bias, labor disruption, and even loss of human control over advanced systems. So there's some other concerns that have been raised about IP rights, privacy, trade secrets as the AI ingests and reproduces protected material. And we've got a podcast on some of the legal developments around AI rights, IP rights as a result of AI that you can listen to, but I'm not going to get into that today. Now, here's the caveat. This report itself is not law. It creates no legal obligation. This report is what they built from. So if you really want to understand the law, it's a good idea to understand the report itself. Think of it as your Rosetta Stone for what's coming next. Now let's talk a little bit about the federal picture. And meanwhile in Washington, we've seen that California is thinking out loud. So what is the federal government doing? Mostly gridlock. They've been considering AI legislation, and the concerns federally are the same ones we talked about: cyber, bio, misinformation, etc. And there's bipartisan anxiety for sure, but we do not have a comprehensive federal AI statute. That debate is stalled on the familiar fault line: innovation versus safety, American competitiveness versus guardrails, America versus China, all of those issues. So there's one federal development in particular that's worth noting yet again. Congress did consider a moratorium, and that's a measure that would have banned states from enforcing their own AI laws on the theory that we should have a single national standard rather than, every company having to deal with 50 different sets of standards. And the Senate voted to strip that provision out of the recent bills. So that didn't happen. We don't have it. We don't have preemption. So think about that. We don't have a federal law. It's Washington is deadlocked. The preemption didn't pass. So the practical effect is that the states are now the de facto regulators of AI in this country, and in particular California, because California has really been, in some respects, leading the way. And these are the rules that are among the rules that might bind you if you do business in this state. So when people say, let's wait for the federal framework, answer is there isn't one, and you may be waiting a while. And up till then, you're probably going to be governed by what's going on in Sacramento. So to dive kind of more specifically into what some of these rules are, because remember, this framework is not law yet, it's just a framework, but we do have some law. So first of all, AI and employment. That part hits you right now. As of last October, these rules went into force, and they cover employers in California now. And it's the employment discrimination framework that these are aimed at. So the California Civil Rights Council finalized regulations governing the use of AI and automated decision systems, ADS, in employment, and they took effect last October. It's not brand new. They just clarify how our existing anti-discrimination law, the Fair Employment and Housing Act, FEHA, applies when you let software help you make a decision, an employment decision. So first of all, who's covered? Well, not quite all employers in California. To be precise, it tracks FEHA's existing coverage, which generally means employers with 5 or more employees, and critically, agents acting on the employer's behalf. I'm going to come back to that in a second. Secondly, importantly, in terms of definitions, what is ADS? ADS, automatic decision systems, is a computational process that makes a decision or facilitates human decision making regarding an employment benefit. Note that the word facilitates, doesn't mean it just decides for you. If it helps you decide, it's covered. So ADS can draw on artificial intelligence, machine learning, algorithms, statistics, or other data processing. So in real life, what that means is are things like resume screening software that filters for terms or patterns, tools that score video interviews by analyzing facial expressions, speech, or voice patterns, online assessments, questions, puzzles used to evaluate candidates, any software that targets job ads to particular groups, promotion recommendation engines. If you use any of these, you're using an ADS, and you may be within the scope of these rules. Now, it's not everything in the world. The regulations do have some exceptions. Ordinary word processors, spreadsheets, navigation, spell check, calculators, provided that they're not making any employment decisions. So that's ADS. How does this get you in trouble? And here's the heart of it. And here are the things that employers really need to understand. So first of all, an ADS can constitute a discriminatory practice if the tool produces discriminatory outcomes against a protected class, race, age, religion, national origin, sex, disability, and so on. That would be a violation. Now, it covers disparate impact, and the discrimination does not have to be intentional. So an algorithm that nobody ever meant to be biased, but nonetheless produces biased results, can still violate the law. Good intentions are not a defense. So secondly, the regulations make clear that a third party, an agent, like a vendor or staffing agency that runs an ADS for you, can create liability. So you can't outsource your way out of liability. If your hiring vendor's tool discriminates, that exposure can land on you. And the regulations introduced the concept of a proxy, a characteristic that's closely correlated with a protected trait. So a system that screens on a neutral looking variable that's really a stand-in for something like, I don't know, race or disability, that can get you in trouble. And finally, there's also a specific trap on disability in particular. Assessments like those questions and puzzles that elicit information about a disability might constitute an unlawful medical inquiry and disability discrimination problem under FEHA. So an innocent screening tool that's gamified could create a separate problem entirely. So what do you do if you're in that scenario? What's your defense? And this is really the constructive part. What should California employers do? So the regulations expressly say that anti-bias testing is relevant evidence in your defense. If you're sued, the quality, the efficacy, the recency, and the scope of your bias testing efforts can support your defense to a discrimination claim. The flip side's clear as well. The absence of such testing can hurt you. So the regulations are pretty much inviting you to audit your tools, and they also penalize you if you don't do that. So 4 action items I think we can take away from this. Number 1, take inventory, identify every AI or any algorithmic tool that touches hiring, firing, promotion, or employment benefits. Probably have more than you think, especially embedded in your vendor platforms. Second, conduct some bias audits of those tools and document them. Recency counts, so this is not a one and done. And third, recency counts, so it's not a one and done. Third, keep your records. The regulations require retaining employment records, including automated decision data for a minimum of 4 years. And fourth, meaningful human oversight, right? So train your HR and your management teams on what these definitions are, press your vendors. And for me as a corporate lawyer, what that means is get contractual representations and audit rights, because their tool can become your liability. Okay, next, SB 53, Transparency in Frontier AI Act. And this is really the headline here. It was signed into law last September. It took effect January 1, 2026. This is the nation's first law specifically targeting frontier AI safety and transparency. And it's a direct descendant of the working group report that I talked about earlier. Who does this cover? Well, most of you who are listening to this, if you're a startup company, you're not directly regulated by this because it targets developers of frontier models. And those are the most advanced, most compute-intensive AI systems, and the heaviest obligations fall on what the law calls a large frontier developer, which is defined by 2 thresholds. More than 500 million in annual revenue and training models at or above 10 to 26 floating point operations. It's a small club. I mean, it's the major AI labs, but you should understand it because it's setting a template that's going to spread. Like any laws in California, you just watch. And also because your own AI vendors might be within it as well. So that's what it covers. What does it actually require? 4 things. First, a published frontier AI framework. Large developers have to create and post a document describing how they assess and mitigate catastrophic risk, bioweapon, cyber attack, loss of control, etc., and how they fold in national and international safety standards. Secondly, transparency reports. When a developer deploys a new frontier model, it publishes the model's release date, capabilities, uses, restrictions, part of a model card. And large developers add summaries of their catastrophic risk assessments. Third, critical report, incident reporting to the Governor's Office of Emergency Services. So within 15 days of discovery or 24 hours, if there's an imminent risk of death or serious injury, plus a quarterly catastrophic risk summary from large developers. And fourth, of course, whistleblower protections for employees who flag safety concerns and a public compute cluster called Cal Compute. So this thing does have, whoops, this thing does have some teeth. Um, it has why it matters. The Attorney General enforces it. There's civil penalties of up to $1 million per violation, and the Department of Technology will revisit those key definitions every year so the thresholds move as the technology moves. So that's the adaptive report that I talked about earlier. So now we get to, oops, why it matters even if you're not covered. Again, this is a blueprint. And by the way, New York's RAISE Act and other states are watching. So this is the leading edge of a national pattern. And even if it doesn't bind you, the vendors building the models you deploy are publishing those frameworks and transparent reports. That's free diligence material. That gives you a roadmap that you can use when you evaluate and contract for AI tools. Okay, now we're ready for two last things to watch. These are both aimed at employers. First, the No Robo Bosses Act. It would have required employers to notify workers before using automated systems in employment decisions. And it would have barred relying solely on those systems for discipline or termination. That bill was vetoed by our governor last October because it just swept in too many ordinary tools. But it's already back. And looks like we're going to get a new governor soon. So who knows what happens. But in February of this year, it was reintroduced, narrowed a little bit to address some concerns. So we have a post-use notice rather than an advance notice. We have a tighter list of prohibited uses like predictive behavior analysis and compensation decisions. But expect some version of the your boss can't be an algorithm law to come back. So keep an eye on that one. Second one, and this is a little more subtle, the Civil Rights Council here in California regulations are not the only AI in employment rulebook. We also have the California Privacy Protection Agency, which has its own automated decision-making technology regulations under our State Privacy Act. And that package took effect January 1, 2026. And the main obligations, notice, access appeal rights, opt-out risk assessments, do not actually apply until 2027. So a single AI hiring tool can trigger two regimes at once, civil rights discrimination rules and privacy rules. So when you do the tool inventory, you'll have to map against both. You can't assume FIHA compliance is everything. All right, so what to do now? So let me leave you with, something to take away. California has moved from talking about AI to regulating it. The expert report gave us the philosophy, trust but verify. Congress gave us a vacuum, and that made California's rules the ones to watch. The employment regulations are live now and reach California employers covered by FIHA, right? That use algorithmic tools. So audit those tools, document the audits, keep the data 4 years probably, keep a human in the loop. And then SB 53 set the safety and transparency template. So for developers building the technology with real penalties behind it. So if you take one action today, just inventory where your AI already touches your employment decisions and start documenting your bias testing. That's the highest value thing you can do. And it's the one thing the regulations really reward. I'm Roger Royce. Keep in mind, this is not legal advice. This is just information. So these are new rules and facts matter. So who knows how they apply to you? Make sure you talk to a lawyer before you act on any of this. It's particularly the bias auditing methodology and vendor contracting. So I want to thank you for being here today. And there we go. Roger Rice 10,000 Startups Podcast, and we will see you next week.